Yes.
Yeah, please, Your Lordship. Lordship, I beg to mention admission item number 4 and 6. Here, I'm preparing for respondent number 5, that is the Nagaland Lokaita. We have been recently engaged and we need some more time to file our counter.
Okay, what about 5?
Lordship, here
4,
we are not.
5, and 6.
We are.
Yes,
I'm
those
preparing
are
for
analogous
this.
matters.
Right, okay, so we'll have to adjourn 5 also, the whole.
Yes,
yeah?
Lord.
Yes.
Yes, Lord.
Third, Mr.
I, Jamir.
I, Zamir, learned counsel for respondent number
5.
5, who has prayed for adjournment since mentioning that they have been recently engaged to represent respondent number 5 and that they may be given some more time in this matter. Yes.
Lordship, this matter has been pending since 2018. Lordship, if the Lokaita can expedite the
Yes.
filing of the
Yes.
affidavit in
Yes.
the year list.
Mr. Fukaso Forte, learned counsel for the petitioner, submits that this matter has been pending since
2018, Lordship, this is a 2018 matter. 2018.
2018, and that
And
The
the Lokaita
respondents-
is yet to file it.
and the respondents number 5, respondent number 5 may take may take necessary steps immediately. Accordingly, list this matter after
3 weeks, Lordship.
3 weeks.
Lordship. Obliged, my lord.
May I please, my lord? I beg to mention here in item 19 and 20.
Yes.
Your lordship kindly list this matter after 2 weeks.
Hearing matter.
Yes, your lordship.
Heard, Miss
Writ.
V. Thare, learned counsel for the petitioner,
Yes, your
who
lordship.
has prayed for adjournment of this matter, which is not objected by the respondents. Is it? List this matter after
2 weeks.
2 weeks.
Yes, your lordship. Your lordship, I beg to mention item number 8. Your lordship, yeah, I'm still, I've sought for clarification, so kindly grant me 3 weeks' time.
Miss
AIME,
AIME, learned counsel for respondent number.
state respondents.
Okay, learned government advocate for the state respondents, has prayed for adjournment since she has yet to receive instructions from the state government.
Or counsel for petitioner.
Miss so-and-so appears on behalf of the petitioners. In view of the above, list this matter after 3 weeks.
3 weeks, your lordship. Your lordship, item number 17, on behalf of the additional AG, your lordship.
Okay.
Paragraph's comment is awaited, so kindly let the matter come up after 3 weeks.
Okay, Miss so-and-so, learned government advocate.
Your lordship, in this case, we got the instruction to represent private respondent number 6, your lordship. We're yet to file Bakalatama.
Okay. Miss so-and-so, learned government advocate for the state respondents, has prayed for further time for filing of the counter affidavit, while Miss
Lumika Kinimi.
Limika Kimili appears on behalf of the private respondent number 6 and has prayed for time for filing of the counter affidavit.
May please, your lordship. Lordship, there is an interim order dated 25/8/22, lordship. If
Okay.
the adjourn can continue.
Miss so-and-so, your good name please?
Mika.
Mika, learned counsel for the petitioner, has prayed that the interim order passed earlier may continue till the next date. Accordingly, list this matter after 3 weeks. In the meantime, interim order passed earlier shall continue till the next date.
Your lordship, hearing item number 21, on behalf of Thibapom, kindly let the matter come up after 2 weeks.
You're for the respondent?
Yes, Your
State
Lordship. State
respondent,
respondents.
yes. Miss
AIME,
AIME, learned government advocate, appearing on behalf of Mr.
Thibapong.
Thibapong, has prayed for adjournment of the matter, while Miss
Mika.
Mika, learned counsel for the petitioner, has not raised any objection. In view of the above, list this matter after 3 weeks.
Much obliged.
Yeah, please, Your Lordship. Lordship, I beg to mention item 14 on
1-4.
behalf of item
Yes.
14.
Yes.
1-4, on behalf of Supong Menla, Lordship, for the state respondent.
Mr. So-and-so, learned government advocate for the state respondents. Appearing on behalf of Mr.
MS Supong Menla.
M. Okay, M.S. Supong Mil Chung has paid for adjournment, which is not objected by Mr. So-and-so. Yes.
N. Nongkumar.
N. Nongkumar, learned counsel for the petitioner. In view of the above, list this matter after 3 weeks. Yes.
Please, Your Lordship, I beg to mention item number 9 to 12, Your Lordship. Here I'm yet to file counter in this matter. So kindly grant 2 weeks' time, Your Lordship.
Ms.
Inaholi, Your Lordship.
Inaholi, learned government advocate for the state respondents, has prayed for time for filing of their counter affidavit. Ms.
Atsala Kips.
Aksala Kips, learned counsel for the petitioner, is present. List this matter after 3 weeks.
Your Lordship.
3
Much
weeks.
obliged.
Obliged. Yeah, please, Your Lordship. Your Lordship, I beg to mention item number 13.
1-3. Yeah.
Item 13 on behalf of my senior, Mr. Gauhati. We are yet to get instructions, so kindly grant us 2 weeks' time to get instruction and file our affidavit.
Okay. Mention is made on behalf of Mr.
Gauhati CGSC.
Young Gauhati, learned CGC, for adjournment of the matter since they have yet to receive instructions. Mr. So-and-so, yes.
I intend for the petitioner, Your Lordship.
Appears on behalf of the petitioner. In view of the above, list this matter after 3 weeks.
Your Lordship, there is an interim that may be continued.
Meanwhile, as prayed for, the interim order passed earlier shall continue till the next date.
Much obliged.
May I please, Your Lordship? I beg to mention item number 7.
7, yes.
Lordship, pleadings are completed. Let it come up for hearing next week.
Do you agree pleadings are complete with the government?
Yes, my lord. Since 1/9/2022, the matter has been listed
Okay.
for admission hearing, but
Let it, if it's
So
for
far,
hearing.
Okay. The learned counsels for both the parties are present, and it is submitted that pleadings are complete, and that this matter may be listed for admission hearing.
yes, my lord.
Accordingly, list
There
this
shall be
matter for admission hearing after 2 weeks.
No, my lord. Next week on 3rd or 5th, my lord. 3rd. On 3rd of next one. my lord.
Make it after 2 weeks. This is matter after 2 weeks.
Lordship,
In the
Lordship.
meantime,
My lord, in that
interim
case, let
order.
it be a fixed item.
Okay, you want a fixed date? Let's just matter on, if, should we make it the 3rd? No. When do you want it then? On the 9th? On the 10th?
Yes.
This
as
is
a-
matter
as
on
fixed item.
10, 10, 20, 30 as a fixed item. In the meantime, interim order passed earlier shall continue till the next date. Yes.
For motion, item number 1.
Yes. What's this IE about?
This is for modification and alteration of the order passed in the main case, Lordship.
Yeah, please, Your Lordship. Lordship, I am filing my objection to the IA in the course of the day, Lordship. So if my learned senior agrees, if the matter can be heard tomorrow.
See,
Yeah,
the matter has come up for the first time. Okay. What is it about, this IE?
This is for modification and alteration of
Okay.
the interim order.
Okay, where's the interim order dated?
22/8/23.
22/8, where is it? Page?
Page 50, no,
Where's the order which you want to be
58.
modified? In the IA, page 58.
Annexure K.
Okay. So who is the applicant?
Respondent number 4 has filed this IA.
Okay.
I'm the writ petitioner in the main petition.
You're representing
Okay.
respondent number 4, is it?
No, I'm for the respondent number 4.
Who has filed this
And,
application? Yes.
Interim order has been passed ex parte, Lordship.
Okay.
And then after getting the order, a status quo order has been passed. And the petitioner is taking advantage of the status quo order passed by this honorable court. Because on the day of passing the order by this honorable court, he has forcefully encroached into the land of the applicant, and then he was residing there. And that day, although the trial court and the revenue court has examined all the documents and found that he is an encroacher, illegally encroached, but then immediately after passing the order passed by the revenue court, the petitioner approached this honorable court and prayed for interim stay. So on the day of passing the status quo order, the petitioner was still within the compound. Therefore, taking advantage of the order passed by this honorable court that look, the High Court has passed a status quo order. On the day of passing the status quo order, I was residing inside the compound, so High Court has given the right to me to occupy this. So taking advantage of the status quo order, the petitioner is still residing in the encroached land. That is how we have filed this application for modification of the interim order. With regard to the prayer made by my learned friend, that I think she is deprived of her senior. So,
Okay, so
and
we
she is
have
praying
to,
for taking up the matter tomorrow. Let it be heard tomorrow, Lordship,
Okay.
as first item.
we have to interrupt the status quo order. What does it mean? Isn't it?
Lordship, yes.
Heard Mr. C.T. Zamir, learned senior counsel for the applicant, who has submitted that this interim order, this IA has been filed for setting aside, no, for modification of the interim order dated 22/08/2023, passed by this court. Ms.
Ms. Lucino.
Lisuno, learned, you are the government advocate, learned counsel
No,
for the
in the IA, I'm for the opposite party.
Opposite party
and I'm the
number? learned counsel for
The
the
petitioner, opposite party.
opposite party. Only one opposite party, is it?
Opposite party number 1.
Number one,
Respondents are
yes,
opposite.
learned counsel for the opposite party number 1 submits that since her senior, Mr.
Imti Longjam.
Imti Longjam, is not able to appear today, she has prayed that this matter may be heard tomorrow and that they will be filing there. Have you filed the
They
original
have already
objection?
filed today and I
I'll be
have
filing it
received a
today.
copy of
But
that.
it's not here, it's not here.
I
It's
received
just-
it.
I recorded it.
Okay,
I'll be filing it
and that they have filed their written objection today. She has prayed that the matter may be adjourned for hearing the next day. That is on, what's the 26th?
26 tomorrow.
9,
But if the
2023.
interim may be continued till tomorrow in the writ petition.
Accordingly, list this matter on 26/9/2023. Meanwhile, the interim order passed earlier. Obviously, it's going to continue. It's not been set aside, isn't it? Interim corner.
Since
Oh, what
the writ
is the-
petition is also listed today.
Okay, meanwhile, the interim order shall continue till the next day of listing. Yes.
Much obliged.
For motion, item number 2.
Minutes. But this is a writ petition under Article 226 of the Constitution
Yes.
against the state of Nagaland. I am praying for issuance of a writ of mandamus to the state of Nagaland for regularizing the services of a very hapless woman who was abused and exploited by the state as a bonded labor for almost 35 years. She was employed as a contractual sweepress in the office of the state. in 1984. And she kept working till 2019, when one fine morning she was asked not to come, saying that you have attained the age of superannuation. So if she has attained the age of superannuation and she has to be retired from the service of the state of Nagaland, she was entitled for all other benefits, and for which she has been regularly demonstrating and on which nothing was done, despite the favorable reports by the junior officers in her favor. So in this case, Lordship, there are 2-3 issues. One is the regulation of service to which she is entitled in terms of the law laid down by the Honorable Supreme Court. In the case of this ONGC Limited versus Petroleum Coal Corporation and Coal Labor Union, their Honorable Apex Court has said that if an employee works for 240 days continuously, then he or she becomes entitled for regularization as in vacancy arises, regular vacancy arises.
Yes.
Of course, I mean, state.
So has the vacancy, this thing?
Vacancy has arisen because it's a huge period of 35 years, Your Honor. She started working from the 1st of July 1984 and kept working in the same post, in the same station till June 2019, and when she was asked on 30th June 2019 not to come because she has attained the age of superannuation. So unless the state says, that is for them to prove before this honorable court that during this period of 1st of July 1984 till the 30th June 2019, not a single post in the cadre of sweepers, I mean rank of sweepers, arose in the state of Nagaland, and not a single recruitment took place. If that is the case, then probably I will have a weaker case. But n number of appointments have taken place. That is what this Honorable Supreme Court has covered in its lengthy judgment. So, Lordship, let them come back to my lords and say that what is the position. Factual position will be known to them only. I'm not part of the state. I'm only a victim. So I will pray that they should come with clean hands before this honorable court. Because law is very clear. There is another judgment by Honorable Apex Court of 2016. This is
Okay.
sorry.
Now, concerning this, you're saying that this is a case of bonded labor.
I am saying, Lordship.
If you're saying it's a case of bonded labor,
No.
then don't you file some FIR or something?
I
Under
mean,
the Act?
that's a separate cause of action, Lordship. Here I am right now for the financial entitlement. The poor lady has no source of living today. She's living on the streets and I mean the help from her community members. So that has to be redressed first. In fact, I will praying to my lords that the state should be directed to give her some provisional pensionary relief immediately, at least few thousand rupees per month, so that she can sustain herself. I mean, it is cruel, Lordship, that an employee who has worked for 35 years for the state of Nagaland has been left to beg around the road. It's almost cruel. Apart from the violation of the Bonded Labor Abolition Act and Article 23 of the Constitution, at least she should be given
Yes,
2
anyway,
meals a day.
we'll issue notice, but I am interested that you should invoke this Bonded Labor Act when the other problems.
I will take care, Lordship. Yes, Lordship. I go down to my lords are very much on my point. It's a very serious issue, Lordship.
Because it appears that you have rescued her.
Almost.
When you say bonded labor,
Lordship,
you rescue
of
people
course, Lordship, I
from.
come from Delhi, but my colleague Mr. Lotha has probably found it out. And we are doing it pro bono. We are not, because she has no position. She is not in a position to get 2 meals. Because she comes from the community, Mr. Lotha also comes. So he found out, then he asked me, and we said that we will approach the Honorable High Court seeking the intervention.
Anyway, we will
The
issue
state
notice.
is pathetic, Lordship. I'm extremely scandalized by a state can do like this.
We'll issue notice, whatever.
Some provisional relief, Lordship. I mean, that necessary. On humanitarian ground, a person cannot be left to beg and die out of hunger and everything after working for 35 years for the state.
You have to show with proper documents that she's,
Yes, Lordship. Yes, Lordship.
not at this stage, we'll issue notice first. Okay.
Some relief, Lordship. I still pray to my lords.
Heard Mr.
I am Mr. Srivastava.
Shivastra,
With
Learned
Mr. N.J. Lotha.
Learned Counsel for the petitioner, assisted by Mr.
N.J. Lotha.
Njit Lotha, Learned
Advocates.
Counsel. This is a petition filed under Article 226 of the Constitution, read with Articles 14 and 21 of the Constitution.
And 23 also.
And Article 23 of the Constitution, along with the provisions of Bonded Labor System, within brackets, Abolition Act 1976, read with the provisions of the Minimum Wages Act 1948. The Learned Counsel submits that there has been a gross abuse and exploitation of the writ petitioner, which is akin to bonded labor, and there is a consistent violation of the human rights of the petitioner.
Even fundamental rights, Lordship, statutory rights, legal rights, all kinds of rights.
Oh, rights, okay, we'll make it, while human rights, it's covered with that.
Lordship.
Who submits that the petitioner, who was appointed as a sweeper, grade 4, in the office of District Sports Officer, Wako, Government of Nagaland, on 22nd/07/1984, with a monthly fixed pay of rupees 300 per month, wherein her services were extended from time to time under the same term and conditions. And in 2007, her fixed pay was enhanced to rupees 3,000 per month after the expiry of 35 years. However, when was she, however, on her superannuation on 31/06/2021, she was left without any pensionary benefits or any gratuity and other benefits, in spite of her long service of 35 years in the government of Nagaland. Full stop. The Learned Counsel submits that the Apex Court, in the case of ONGC Limited versus Petroleum Coal Labor Union and others, reported in 2015 2LJ 2057 SC, has clearly laid down
That any employee working for 240 days continuously.
that an employee who has been working for 240 days continuously should be granted
Regularization as and when vacancy arises in the cadre.
regularization as and when vacancy arises in the cadre. The Learned Counsel submits that the petitioner has not been given her entitlement as per the existing law and the decision of the Apex Court.
Yes, Lord.
Notice may be issued to the state respondents. Ms.
Miss Inoli.
Enoli accepts
1 to 4.
notice on behalf of the state respondents number 1 to
4,
4.
Your Lordship.
Yes. Extra requisite copies of the writ petition is to be accordingly furnished to the respondents. List this matter after. Yes, 3 weeks.
And if they have to file counter, I will
Yes.
take 2 weeks' time to file my rejoinder, Lordship, thereafter.
Okay, list this matter after 4 weeks
4 weeks, Your Lordship.
for filing of their counter affidavit. Yes.
Obliged, Lordship.
For admission, item number 3.
Mother, the petitioner is the wife of one the party that is interpret her, my lord. And we allow to take your lordship to annexure 1. page 17 of my writ petition.
Yes, okay, let me see what is the last court's order first. Now, in the last court date, this court had mentioned, okay. Yes, go ahead.
So, my lord, I may be allowed to read out. Annexure 1, page 17 of the writ petition. Page 17, madam.
Yes. Is it annexure 1?
Yes, madam.
Oh, okay.
So, my lord, this is Deputy Commissioner, Twin Sound District, Office Order Establishment number 131 of 70. Appointment contingency bed interpreters, my lord. Interpreters. The following persons under the establishment of EC Twin are hereby temporarily appointed as contingency bed basis in the scale of bed, my lord. So it is clear. Plus, inline special base such and such, basic base subject to minimum of rupees such and such and maximum of such and such. And all other allowances as are admissible under the existing rules from time to time, with effective date is 1/8/1970, my lord. Following against the post newly created. So it is a sanction post, newly created by authority number APA 5 of 970/2, dated 28 July 1970, my lord. So that is, the nomenclature is contingency bed, but it is in the scale of pay against post creation. That is sanction post, my lord. That is the whole issue. So I may be allowed to read out. The petitioner husband, it is not a single appointment, it is as many as 16 persons against all the particular sanction posts. Serial 1 is Mr. Such and Such. He was a dog runner in Shamato, that is AEC headquarters. Number 2, Mr. Such and Such, Biyun, Kipri. Number 3, such and such, Biyun, Bongru. 4, Biyun, Bongru. 5, Biyun, Toku. 6 is the issue now. Ulysses Santem, NLC is Nakalan Labor Code. Was in Chari. So all these 16 persons, they were serving in various capacity. So the appointment is purely temporary. So it is temporary. It's the nomenclature. Contingency is the nomenclature. That is how everything wrap up. So it is, the appointment is purely temporary, subject to termination at 1 month's notice from either side. So service condition is temporary appointment. In the interest of public service, the above persons are posted to their present respective post. That means from labor to interpreter in the same Chari. Earlier it was circle officer, now it is EAC, Extra Assistant Commissioner, my lord. So if your lordship is clear that the appointment was, nomenclature is contingency, no doubt. But in the scale up, against the sanction post, my lord, then the B is drawn from page 18 The Accountant General, Assam Nagaland Meghalaya, earlier it was Shillong. So it is against the consolidated file. Then, my lord, I may be allowed to take your lordship to page 90. So the issue is from 1/8/1970, which is contingency nomenclature, in the period of this from 1st June 1974, my lord. So, same appointing authority, DC Tunsang, number 1974, appointment of grade 2 interpreter, that is promotion, my lord. Sri Ulysses Sanctum, contingency paid BP Chari. Under the establishment of DC Tunsang is promoted, my lord. So when it is a promotion, it has to be taken that earlier services recollect. And temporarily appointed to the post of grade 2 DB in the scale of pay of rupees 120. That is higher by 20 rupees.
Okay.
Such and such, such and such. All other allowances admissible under the existing rule from time to time with, my lord, effect from 1st June 1974. The question is, from 1st 1/8/1970 to 1st June 1974 is the issue before your lordship.
Okay.
So it is a promotion. Then what happened? Service book was maintained. Then there the question is in the service book, my lord. Type copy is page 21A. The entry in the service book is appointed as contingency paid DB in the scale of rupees 100. Then it is written, this is clerical, bracketed fixed.
Page?
Page 21A. 21 is not legible, that is why 21A. Type copy. So the question is here, appointed as contingency, yes, contingency, appointing authority, DB in the scale of rupees 100, but bracketed fixed, which is not in the order, appointment order.
Okay, so that's your point, is it? So your appointment, let's come back to your appointment order.
Page 17.
It says, okay, you're saying it's scale of pay and not 100 fixed.
No.
Okay.
No. That is the appointment authority, appointing authority order. So in the time of entry in the service book, clerical error dropping, that is fixed.
Yes, 100 fixed.
But 100 is reflected clearly. Plus, when it is fixed, it cannot be plus. So all other allowances is given 35, the special day 35, which is.
But here it mentions, it doesn't just mention rupees 100 fixed, it mentions the scale rupees 100. It says scale rupees 100.
Right. Appointment order is clear, rupees 100.
Scale of pay rupees 100.
Yes.
Here, so here again it says scale 100.
Yes, scale is given, but it graph up is the bracketed fixed.
Okay.
My lord. That is how some problem crop up. So my lord, if your lordship is clear about it.
Yes.
Page 26, Annexure 4. When the old man was running for the service, Malata, I maybe I want to take your lordship to page 25. Page 25. Last one. On Malot.
Yes.
Yes. Last one. On attaining the age of superannuation, Sri Ulysses Sanctum, Interpreter Grade 2, is hereby allowed to retire from government service with effect from 1/7/1981 formal. Right? Numbers such as such. So the issue is whether he have completed 10 years or not. That was the whole issue. Because of the word contingency.
Yes, go ahead.
Now, without getting any retirement benefit, he died. That is page 26. Date of death 16/9/2002, my lord. So one aspect of the matter your lordship may take into account is these people are from
where?
Titla backward area. So you may not have that knowledge. Then only in the year 2007, page 27, Annexure 5. Itu. To the DC to his son, subject prayer for grant of service pension and family pension to my husband, late Ulysses Sanctum, retired Capacity Grade 2 from 1/7/1981 forenoon, and family pension from 16/9/2002 to Mrs. Tang Janla Sanctum, wife of late Ulysses Sanctum, my lord. Sir, with due respect, I have the honor to put forward the following facts of my husband, late Ulysses Sanctum, ex-Capacity Grade 1, retired. Service particulars of your establishment before you for favor of your kind consideration in sympathetic order. 1. That, sir, my husband, late Ulysses Sanctum of Old Mangaki Village, District Dunsang, was first appointed as contingency paid deposit in the time scale of rupees 100 to 175 per month, plus all other allowances, as are admissible under the existing rule from time to time in Nagaland with effect from 1/8/1974, after serving more than 10 years as an LC. So he was a Nagaland labor corps. Prior to that, under the CO Circle Officer Chari, White DC Tunsang Office Order Number 18, dated 18/8/1970. Copy includes the appointment was made against the post newly created by order dated 28/7/1970. 2. That my husband, late Ulysses Sanctum, was further promoted to DB2 interpreter in the time scale of pay of rupees 120 to 200 per month with effect from 1/6/1974, while Tunsang DC Tunsang order dated 10/6/1974. 3. That my husband, late Ulysses Santam, was allowed to retire from government service and attaining the age of superannuation with effect from 1/7/1981 formal, while release order dated 10/2/1981. In this connection, I beg to state here
Can you
that
repeat that? 1981 with effect from, okay, and released on
Yes.
10th. Okay, fine.
my lord.
Yes.
In this connection, I beg to state here that though my husband was allowed retirement from government service as per the rule, their pension and family pension had been denied on the ground that my husband had not completed even 10 years of service in the government and allowed only service gratuity payment, my lord. However, on rechecking the service book entries in other relevant orders in document, the following observation discrepancies in the service book were found for reconsideration to grant pension and family pension to my husband, late Ulysses Santam, bracket A, that as stated above in the first paragraph, late Ulysses Santam was appointed in the time scale of year. B, after grade with all other allowances as admissible from time to time under the government. But it is seen in the service book entry that late Ulysses Santam was appointed as contingency paid fixed of rupees 100, which is quite contrary with the original order, and no yearly increment was granted for the year 71 to 3, which falls on 1st of August, which seemed to be the main reason for to grant in sanction pension and family pension, which will be same at service book page number 4. B, as stated above in the second paragraph, late Ulysses Santam, ex the DB grade 2 retired, was promoted to the grade 2 DB with effect from 1/6/1974, which confirmed that the incumbent was entitled to get all service benefits from the date of his joining in the service from 1/8/1974. Had the incumbent service from 1/8/70 not been counted as service, there was no point of promoting him to DB2. Therefore, as per the service rule, promotion means the previous service is counted as service and it's a promoted. In view of the above mentioned facts, I earnestly request your kind authority to please re-verify my husband, late Ulysses Santam pension case in process to the higher authority, as my husband had already completed 10 years, 11 months of service on the date of his retirement. Further, I beg to inform you that my husband, Sri Santam, retired DB grade 2, expired on 16/9/2002 at 6 a.m. at Mangaki village. And a lay action is highly appreciated. So it is term imprisonment, meaning totally illiterate.
So they have come after how many years?
There is 10 years, 11 months. Application is after a long care, that is, he died on 16/9/2002. Then it is submitted on 2/8/2007. Madam.
Yes, 7 years, 5.
Yes, madam. Then what happened? Again, another representation was made to the DC in 2010. You will see a lot of these representations are not dated in many cases. In my case also, it is not dated, except the receiving authority giving the date. To the DC to Nagaland, subject request for finalization of pension and family pension in respect of late Ulysses Santan, retired interpreter under establishment of DC Twinsam. Sir, I beg most humbly submission aim to respectfully state the following four few lines before you for favor of your kind consideration and necessary action. That, sir, I am a poor widow of late Ulysses Santan, retired TV under the establishment of DC Twinsam. My late husband has been serving as interpreter about 11 years, exactly as 10 years, 11 months. In being retired, now service during the year 1981. In government could not grant him pension sanction as such prolonged process. My late husband had died during year 2000. And all pension process documents were misplaced and could not able to trace out meaning. Moreover, I am becoming older with having my own knowledge about the matter, thus the delayed process of my family pension case. Lastly, help of my only son who is staying at Timor as government servant under medical department. Timor submitted the required documents in the process family pension case. May I therefore request your kind authority to look into the matter, consider to move the process to the government at an earlier possible. Through your esteemed authority, please, I shall remain ever grateful for your act of kindness, my Lord. That is second representation. Then page 30, the appointment authority have processed dated 3rd November 2011 to the additional chief secretary. It is commissioner, practical, Nagaland Kohima. Subject forwarding of pension paper in respect of late Ulysses Santan, retired TB Twinsam. Madam, with reference to the subject cited above, I have the honor to forward herewith the following pension papers in related documents along with service book in respect of late Ulysses Santan. This is grade 2 DP under the establishment of DC Twinsam for favor of your kind consideration in further necessary action place. 1 is service book, 2 pension form number and such, then 3 10-month service calculation, 4 descriptive rule, 5 thumb and finger impression, 6 succession certificate, 7 no demand certificate from electrical PhD, BWD housing, 8 deed certificate from statistical and medical department, 9 birth certificate of claimant in nominee, then a copy of appointment order, my Lord.
Yes.
Then it is signed on 2011. Then the commissioner office wrote back office letter dated 15 September 2012, page 31, to the DC Twinsam, authentication of earned leave encashment bill in respect of such and such, grade 2 DB under the additional Deputy Commissioner Long Kim, He died at Long Kim.
Yes.
Appointment was at Chari. Sir, in inviting a reference to your letter number 5612 on the subject cited above, I am directed to return here with life engagement bill along with service book and documents in respect of Ulysses Hongkong X, grade 2 DB under the ATC Long Kim, and to request you to kindly give clarification why beneficial claims is submitted after a gap of 31 years after said incumbent matter. That is the issue. Then, page 32, Annexure 9, by the DC, later dated 30 September 2012, to Commissioner Nagaland, subject resubmission of life engagement bill in respect of such and such, ATC Office Long Kim. Madam, with reference to your letter dated such and such on the subject cited above, I am directed to resubmit here with the life engagement bill in respect of late Ulysses Sanctum X, grade 2 DB of ATC Office Long Kim with the following clarification of the late process. 1. Late Ulysses Sanctum was allowed to retire from active service with effect from 1/7/81 in his pension document work process, but was unable to process in time due to complication in his length of service. In such a juncture, the incumbent expired on 16/9/2002, of which a photocopy of self-explanatory note by the claimant Srimati Thangkel is hereby included. 2. With reference to your office letter dated 15/9/12, this office has submitted self-explanatory explanation along with documents for finalization of family pension by dated 23/12. Hence, you are requested to kindly consider the submitted case for earlier finalization, please. This is from the DC office. Then, my lord, page 33, Annexure 9. This is Commissioner Office letter dated 24 April 2013. Subject, return of service book in respect of late Ulysses Sanctum, retired PB, ATC's office, Long Kim, sir. In inviting a reference to your letter number 76, I am directed to return here with the service book, along with the life engagement bill in respect of late Ulysses Sanctum, retired PB, under the establishment of ATC Long Kim, and request you to properly verify the year of date before issue of office order. Further, requested to obtain non-travel certificate from the Treasury Office. Officer also furnished the reason for the bill prepared in to break up for further necessary action. This is from the Commissioner Office. Then, page 34. This is from DC. Dated 1st June 2013. To the Commissioner Nagaland, subject resubmission of late engagement along with service book in respect of such and such, grade 2 DB, ETC Office, Long Kim. Madam, with reference to your letter dated such and such and the subject cited above, I have the honor to resubmit here with the life engagement bill along with service book after duly obtaining the required information in respect of late Ulysses retired TB office of ATC Office Long Kim. The following documents have been duly verified and corrected for favor of your kind consideration for the necessary action. 1. The date of late Ulysses was 16 September 2002, but due to clerical error, it was mentioned as 16/9.
Okay.
2010. So through what
So
the year 2010.
is this an issue in this case? I don't
No,
think so.
no.
So leave it.
No.
Leave this.
Yes.
Come to the next
The matter
slide.
has been verified and corrected in given initial signature in the error. Non-trouble certificate from.
This is not an issue in this case. His mistaken of date of birth,
No,
death, isn't
no,
it?
no.
So come to the next
No.
point.
Then, page 35 is 2nd August 2013 to the DC leave engagement from the commissioner in respect of such and such. Sir, with reference to your letter number such and such, I am directed to return here the leave engagement bill along with service book in respect of such and such. Under the ATC Longkin, in request you to kindly refer this office letter even number dated such and such in give clarification why beneficial claim has been submitted after a gap of 31 years of the said case. Then the government level wrote to the AG dated 7/10/2014. Malo.
Go ahead.
This is from the AG to the Commissioner Madam. Subject family pension in case respect of late such and such. The issue crop up from here. Sir, in inviting a reference to your letter number dated 14 in confirmation letter, that's a confirmation from the
Yes.
appointing authority, dated 13/5/14 on the subject cited above, I am to state that the pensioner retired on superannuation age on 1/7/1981, but this office case number 8283, that they have all the documents from the date of initial appointment. The pensioners receive service gratuity of rupees and such in lump sum in TCRG of rupees and such after determined without receiving pension as the length of service of the pensioner was only 7 years. That is 70 to 74. Being given as contingency, they've excluded that. That is the reason.
So that's the main crux of the case.
Madam.
Length of service, 7 years or 10 years plus?
Yes.
They're saying 10 years, 11 months.
Madam.
Oh. While they're saying it's 7 years, you're not entitled to
Yes.
pension. Isn't it? Yes.
Madam, that is my whole case. So, since 3 years in 7, Madam, I may be allowed to continue. Pensioner was only 7 years, 1 month in contingency paid for 3 years in 10 months. So this calculation is all the same. Only moreover for pensionary benefit, 10 years of regular service is required. That is what they make an issue. Since 3 years in 10 months has been on contingency paid, which has not been regularized and cannot be counted for qualifying service, hence, as per rule, a government servant will not get the benefit of pension and only service gratuity will be entitled. Copy enclosed.
This is the AG's office, isn't it? Who
Madam.
is representing the AG's office? Okay, fine.
Then, the petitioner issued the legal notice. On this basis, Malo, last part, therefore, I hereby notify you to count the service of this is Ulysses Santam grade 2 with effect from it is 1st August 1970 to 1/6/1974, which is contingency for pension benefit and to pay pension and retirement benefit to my client, such and such. with effect from 1st August 1981 as per the rules. On that basis, Malo, page 39, Annexure 15. This is from the Home Department, JAB, dated 27 May 2015, to the Commissioner, legal notice, reference, office letter dated 7/10, which your lordship has seen. Sir, I am directed to refer to your letter number dated 14 May 2015 on the above cited subject and to convey the approval, my lord, of the government to rectify the lapses as per PNER OM dated 25th November 2009. So, the government has taken a decision. Yes, he is entitled to rectify.
Where's this dated 26 November 2009?
26 November is
What does it
page
say?
48, mother. May I read out, mother?
Yes.
This is PNAR orientated 26 November 2009. Subject counting of contract at top period for retirement. Many departments have sought clarification as to whether the services rendered by employee on contract at top work charge appointment should count for fixing of length of service. The standing guideline of the government is that the period of such service rendered is being counted for increment, leave, pension, and other service benefit exceed seniority, my lord. The regularized work charge employees are also entitled to count in full their continuous work charge service towards pension benefit. Therefore, it is further clarified that the contract at top work charge period thus rendered will count for determining length of service for pension purposes in terms of Napoleon retirement from public employment, Second Amendment 2009. The above decision will be equally applied to both the officers and staffs coming from outside the state who are appointed on contract basis and the employees of this state government in similar cases. So that is the decision of the government, and that is intimidated by this office letter dated 27 2005. It from the government level. Then my lord, page 40, 4th June 2015, to the DC. This is from the Commissioner Office in compliance with the Home Department Office letter dated 27 2015 to DC Tourism. Reference Office of the AG Office letter 7/10/2014, which your lordship had already noted. Sir, with reference to the subject cited above, I am directed to forward herewith a copy of JD number given it annexure previous, that is annexure 15. And to convey the approval of the government to rectify the lapses as per PNR 26/11/2009. This is for your information and necessary action. That is from the Commissioner. Then the DC by later dated 22nd July 2015 wrote to the Commissioner, that is the controlling officer for the whole state. Sir, in inviting a reference to your letter dated, that is annexure 16.
Where are you reading from?
Malota, page 41.
Oh,
This is from the DC, who is the appointing authority.
okay.
Malo. This is to Commissioner. Sir, inviting a reference to your letter dated 4th June, that is Annexure 16, in Home Department, that is Annexure 15, 27 May, on the subject cited, on the above cited subject, the following lapses are being rectified by the appointing authority. That Sri Ulysses Sangam was serving as NLC porter in Chari subdivision, for which his appointment letter is not traceable, my lord. While serving as NLC porter, he was appointed as contingency pay TB in the scale of rupees skill. Plus, such and such basic pay subject to minimum such and such with all other allowances. Appointment letter includes. This appointment, my lord, was made by dated 18 August 1970 in pursuance to newly created posts by authority, my lord. Dated 28 July 1970. Although the appointment letter has mentioned contingency pay DB, he was appointed against the sanction post with proper scale of pay, my lord, along with 15 other as stated above. As your lordship has noticed, 16 of them were appointed by the same order. Further, it is also to mention here that his appointment has been erroneously entered in the service book as contingency pay DB in the scale of rupees 100 fixed, my lord, which is being considered as a clerical error. So this is the appointing authority. So entry are made in the service book by the clerk. So when the appointing authority is very clear about it, matter is there. Hence the qualifying length of service should be considered from the day he was appointed as contingency pay DB in the 10 existing scale of payout as stated for all purpose. The incumbent was further promoted in the scale of rupees 120 to 200 per month, but later dated than June 1974. It may also be pertinent to cite the OEM dated 26 November 2009, which is self-explanatory. This is for favor of your kind consideration and further necessary action, please, Madam. Then what happened? The Accountant General created another issue on their own. This is dated 8/6/2016. To the Director in DIG Police Vigilance in Anti-Corruption Police, Nakalang, Kohima. Subject: family pension case in respect of Ulysses Santam, retired DP interpreter under the establishment of DC Tuisan. Sir, in inviting a reference to the subject cited above, I am to state that the pensioner retired on superannuation age on 1781 by this office case number such and such. The pensioner has received service gratuity such and such, DCRT such and such, after retirement without receiving pension. As the length of service of the pensioner was only 7 years, 1 month, and contingency paid TV for 3 months, 3 years and 10 months only. Moreover, for pensionary benefit, 10 years regular service is required. Now,
So they're taking the same stand which they've taken before, isn't it?
Malo, exactly.
Oh.
Anyway.
In spite of whatever rectification was made, you had mentioned those, but
Yeah,
AG office has not changed its stand. What is the
Yes,
reason?
that is what exactly. Anyway, since the AG have written, the vigilance, they have done all the correction. Since Diwali,
AG is the authority in this matter, isn't it?
my lord,
AG is supposed to be the authority in this matter.
my lord. Then, since they have written, next page, page 43, my lord. This is Vigilance Commission. Directorate of Vigilance in Anti-Corruption Police, Nagaland, Kohima. 11 July 2016. To the DC Tucson. Inquiry in requisition of documents. So, sir, I am to refer to the subject cited above in those state that in view of an investigation being conducted by the Commission pertaining to the pension claim of respect of such and such, under your establishment, the concerned officials who forwarded the said family pension is required for examination and certain clarification matter. Therefore, you are requested to direct the concerned officials under your establishment to appear before the investigating officer, Mr. Sergeant Such, inside at Vigilance Police Station, Kohima, on 2nd July 2016 at 12 p.m. It is also requested to furnish the following original document in respect of Sergeant Such, DC Tunsang. First, appointment order. Appointment order in the post of TV interpreter, service book, personal file, succession certificate in all other relevant documents. Therefore, the desired documents be kindly furnished to the Commission on or before 22nd July 2016. Your kind cooperation on the matter is solicited by the Director of Vigilance. Then, page 44. This is Vigilance again, 28 November 2016. To the Accountant General Manual. Reference, dear own letter dated 8616. Sir, I am to refer to the subject cited above in to state that preliminary inquiry was conducted by this commission to ascertain the genuineness of the family pension claim by such and such, where late such and such, under the establishment of this institution. During inquiry, the genuineness of the pension claimant has been established on physical verification. It has also been established that the actual name of the pension claimant is Srimati Tenjala. In her actual date of birth is 25/11/1940. Secondly, the admissibility for a family pension benefit against the service of late such and such should be taken up as per the relevant government OEM copy includes. Thus, the family pension claim made by such and such is recommended to be genuine, my lord. Therefore, the matter is forwarded for initiating further necessary action from your end. Then, when this vigilance clearance was given, the AG created another issue. That is page 45. Dated 27 to 17. To the Secretary PNR, now first to the Commissioner, second to the Vigilance. Since Vigilance has given clearance, now they have written to PNR. It is the same comments I may be allowed to read out. Madam, in inviting a reference to this office letter dated 17/2014, Madam, and number such and such 6/86/2016, copy enclosed. That is, first was to the Vigilance is 28. Vigilance is Annexure 18. Then the other one is Annexure 13. So they have referred both Annexure 13 in 18, my lord. On the subject cited above, I have the honor to state that the pension retired on superannuation age on 1781 White Office. This office, their own office, case number such and such. The pensioner has received service gratuity lump sum without receiving pension. As the length of service of the pensioner was 7 years, 1 month, and
Same stand, same stand.
Same,
Oh,
it is
yes,
repetition of the same number.
Yes, okay, so,
Then what happened is that PNER, without considering their own OM 26 November 2009, which has been rectified by the government, grab up this issue, my lord. Annexure 22,
yes, page 46.
yes, 11/7/17. This is by one deputy secretary.
Now they've calculated to 9 years.
Yes, AG got what he want from this bill, my lord.
So how did they calculate this 9 years?
My lord,
Before it was 7, now it's 9. Yes, so have they explained how this
my
9
lord,
years?
I was
Yes,
ignorant about this.
there's 9 years here.
Examining such, there is 1 year short of minimum qualifying length of service.
So you're not aware of 9 years
No,
then? How do you explain this 9 years?
my lord, he must have calculated in such a manner that contingency period must have been calculated halfway. That is the most plausible possible.
Anyway, this is for the government to explain how this 9 years was calculated, isn't it? Oh, yes.
So that is the whole issue, my lord. Then I have includes Annexure 23, how it should be counted in cases of ATO. Even though my appointment was in the scale of pay against sanction post. However, the government have issued this counting of seniority for service rendered on ATO appointment. Way back in 75, the undersigned is directed to refer to the subject cited above and to see that it has been brought to the notice of this department for clarification that whether the services rendered by an official on ATO appointment should count towards seniority, including leave, increment in pension, etc. Then decision is, after careful examination, it has been decided that if such ATO services is continuous followed by regular appointment in confirmation, the period of ATO service thus render will count for increment, leave, pension, and other service benefits. So pension is included way back in 75. But seniority in the particular category should count only from the date of regular appointment and should follow the order of merit given by the NPSC order selection board. So pension is clearly included.
So when it says leave pension, there's no comma here, it's just leave pension.
Yes.
So leave, comma pension or leave pension?
It has to be drafting error. Simple as that. Will count for increment 1. Kumaister, as your lordship has pointed out, leave pension is not there. It's not a same word. Leave pension is not there. So it has to be leave pension.
Comma pension.
Yes, my lord.
Okay.
So drafting error and other service benefits when it says other service. Then the next one is in the same line. It's in the case of contract. But it is the period of such service thus rendered will count for increment. My lord, this is a bit clear, as your lordship has pointed out.
Okay.
Leave after that, Komeister, pension, and other other service benefit. So reading the two OM, the confusion is clarified, my lord. So the government stance after filing of the writ petition has totally changed, because this is the appointing authority. You've given all the clarification. Commissioner have already given. In Home Department also have already given. This is the only issue is to count the. It is just because of a nomenclature, that is contingency. Otherwise, it is regular scale
Okay.
against sanction post and then promoted. So, my lord, if I may be allowed to refer to my affidavit in reply now. No, it's not there.
Today it's been listed for admission hearing. So should we admit the writ and then list it for proper hearing some other day?
My lord,
Or you want to, are you
Yes.
trying to
Yes.
praying that it be disposed of at this stage itself? I don't,
everything is completed, my lord.
oh.
Affidavit is there.
So
From
we
both the-
will admit the matter listed for full hearing. Wouldn't that be more appropriate? I think he has convinced the court that he has a case,
Leave it to my lord.
and then we'll let it for full hearing
My lord,
instead of
when your
Trying to-
lordship is sitting, my lord, because we have a
after
problem.
2
I don't
weeks.
have friend.
What?
Both of us,
Hmm.
we have argued the whole 5 days.
Before whom?
His lordship, Kakitu Sima.
Oh, then I
But
think,
then he released it. Then it again listed here. So
that means it was not admitted at that time.
no,
So let's admit the matter
no.
and list it for hearing. I think that will be better.
And it,
Then once it's listed for hearing, it has to be heard anyways. From your point, prima facie, you have made out a case that it deserves to be fully heard, isn't it?
my lord,
Because I think it's basically the term contingency.
Yes,
This is the main issue
Nomenclature.
now, the
Yeah.
nomenclature.
yes.
only that, only that.
So you're saying because of that term contingency, even though he's been given scale of pay,
Lordship.
that cannot be counted for pension.
Yes, yes.
And to have those, you have citations, judgment, something to support your claim?
The rule itself says so, Lordship.
Okay. The rule says even if it's contingency
Yes.
and there's a pay, scale of pay is given, it's still
Anything paid from contingencies.
okay, so we'll have to look into the matter.
Lordship.
We'll admit the appeal,
My lord.
listed for hearing.
My lord,
Heard.
I am
Mr.
the
IMT Longcha, learned counsel for the petitioner, along with Mr.
And Angami, Lordship.
Yes. We've heard Mr. So-and-so, learned counsel for the petitioner, along with Mr. N. Angami, learned government advocate, and Ms. Hombeni, learned counsel for respondent number 7.
my lord.
Having heard the submissions made by the parties, the appeal is admitted and to be listed for hearing after 2 weeks.
My lord, can it be taken up when your lordship is around?
You see, the problem is hearing matters. It becomes a little bit difficult because we have to carry the files, go home. And so someone who's sitting here, I think it's better, isn't it? Just a matter. We'll give you a
Next week,
fix.
my lord.
We'll list it after 2 weeks, but if you're in a hurry, we'll fix a date.
No, just after 2 weeks, Your Lordship.
My lord, that is
Just after
sufficient.
2 weeks.
Much obliged.
Yes, Your Lordship. For admission, item number 15.
May I place your lordship? This has also come up for admission hearing. My learned friend was reluctant to take up the matter today in the sense that it's not prepared today, and requested me to take it. Why not we try tomorrow? Now, Lordship, of course, I'm making this submission subject to your Lordship's convenience. This matter is relating to the reservation policy, where a particular tribe, that is Tikir tribe, which was not recognized as one of the separate tribes in the state of Nagaland. Last year, they were recognized as a separate tribe. Thereafter, the government has issued a notification to allow a seat for this particular tribe. For the Eastern Nagaland, there are 6 tribes, and 25% quota is to be shared among these 6 tribes. That has been the practice over the years. Now, in view of recognition of Tikir tribe, the Eastern Nagaland, the recognized tribes has turned to 7, one more than what was there earlier. What happened is, as per the government notification which was issued on 23rd March 2022, that is last year, they have issued a notification saying that this Tikir tribe should also be included among the 6 tribes, and the reservation quota which has been enjoyed by 6 tribes earlier should be enjoyed by 7 tribes. That means it has to be on rotation basis. But what happened after the notification was issued, although this notification has given the benefit to the Tikir tribe, the present petitioner, which is the Apex Students Organization belonging to Yemkyung tribe, which is a recognized
Okay, one of the many tribes.
This quota has been earlier, Tikir tribe was a sub-tribe of Yemkyung. Earlier it was under Yemkyung tribe.
This Tikir type, you're saying?
Yes.
Tikir tribe is under a Umchung tribe.
Yemkyung tribe.
Okay.
But in view of recognizing this particular tribe as a separate tribe, the government has issued an order. Okay, earlier this 25% quota has been sharing with 6 tribes, but now in view of recognition of the Tikir tribe, let this quota be shared among 7. Cake remains the same, but the consumer has increased.
Right, okay.
And the government, in order to resolve the issue, they have given equal share to all the tribes, which is a reasonable notification. However, the grievance of the petitioner is that this notification has not been implemented by the government till date. And this Tikir quota is included in the Yemkyung quota. Instead of sharing, cutting from little from cutting from other tribes, only from one particular tribe it is being cut out. And they have not implemented that notification, which was there earlier. It was implemented. Therefore, the quota made for Yemkyung tribe has been, they become the loser. Therefore, we just want a direction from this honorable court to issue a direction to the government to to implement their own orders. That is 23rd March 2022 order. You have issued this notification. Please comply with this order. Urgency is, Lordships, what happened? NPC is issuing advertisement after advertisement. Even after filing this present petition, 2 advertisements has already been issued. They have not implemented their own order. Now, about 2 weeks back, the Nagaland Public Service Commission has declared the result of the NCS examination that is combined, which is about 100 posts, starting from extra assistant commissioner, deputy superintendent of police, like that. There are so many posts coming under this. Now that the result has already been declared, another advertisement is likely to be issued one of these days, very soon. And if there is no direction from this court to comply with your own order, government will go ahead with this. And Lordship, what I apprehend is...
Yes. So what in the advertisement, what is the nature of the advertisement? They mentioned the tribes, is it? In the advertisement, they mentioned the tribes.
They have not implemented their own order, that is 23rd March 2022, by which it has stated that the 25% quota should be shared among the 7 tribes.
So names of the 7 tribes have not been listed out, is it?
The declared tribe which has been recognized, that has not been implemented. Earlier it was shared by 6 tribes.
Yes.
Even now also it is meant to be shared by 6 tribes.
Let's see the advertisement. How do they advertise for such post?
No.
Do they mention all these 6 tribes, names of the tribes, or the 7 tribes? Is it?
Let me, Lordship, take to the advertisements which has been done in the past. How advertisement have been issued. Page 53, Annexure L. With regard to the urgency, Lordships, what I have requested to my learned friend is, since all the matters have been adjourned today, let this be taken up and then let me finish my part so that will refresh for you also, and then you can complete it tomorrow.
Okay, we'll adjourn the matter for tomorrow, is it? Will we be prepared tomorrow?
Lordship, here my problem is almost all last week I was out of session. I was
Okay.
and I received the affidavit reply. The reply to my affidavit I received only this morning.
Okay.
So that's why, otherwise there is an urgency. But on my personal capacity, I have some difficulty. That's the only problem.
This is for admission hearing, so you want to dispose this matter at the admission hearing stage itself, is it?
Let it be disposed of at the admission stage. Otherwise, once it is put it in the hearing list, you never know. And in the meantime, the advertisement will be issued and the petition will render in first Lordship.
So when do you want it?
Tomorrow, Lordship.
Tomorrow.
Okay. On the prayer made by the learned councils for both the parties, this matter tomorrow.
For
Yes?
admission hearing.
Yes, for admission hearing. 26, so and so, for admission hearing.
Obliged.
For admission, item number 16.
Matters called out, none appeared for the parties. List after 2 weeks.
For hearing, item number 18.
Yes.
Yes, may I please, Lordship? Lordship, we are praying for back wages salary.
For back wages?
Yes, Lordship.
Okay.
Lordship, here, the gist of the case is that by advertisement number dated in 1/9/2016, 2 posts of driver were advertised in the office of the Deputy Commissioner, Zinopato. And accordingly, I have applied and I've participated in the selection process. And I was in the merit list. And I was appointed to the post of driver. However, while I was serving as a driver, my appointment was challenged by one of the candidates who was in the waiting list, stating that I have submitted a fake driving certificate from one of the institute. So in the course of hearing, the only ground challenging my appointment order is that I have submitted a fake driving certificate. However, the only requirement was a valid driving license. And moreover, I have not submitted any fake certificate. However, at the time of hearing, the petitioner, they have raised another issue, which was not in their writ petition, with regard to my driving license, which was issued in the year 2016. So, at the time of hearing, the judge has assumed that since at the
The
time,
concerned department, is it?
yes,
Okay, disciplinary proceeding, is it?
no,
What
it's not
hearing?
disciplinary process.
Then, at the time of hearing means where? Before which court?
Before this court, as
Okay.
in writ petition number 156.
Oh, okay. Then?
So, the learned single judge assumed that at the time of submission of my application, I have not submitted my driving license. However, my driving license, which was in a booklet form, which was issued in the year 2010, was in a booklet form. So I have applied for smart card, and it was issued in the year 2016. And that smart card I have submitted before the office of the Deputy Commissioner. And when the records was called before this court, my driving license, which was in a booklet form, was not placed before the court.
Oh, the
Was not
records were called for by
Yes,
this
yes.
court. Okay.
And only my smart card, which was renewed, which was converted smart card form in 2016, was in the records.
Okay.
And as
then?
such, my appointment was set aside, and I was released from the service. So, being aggrieved, I have submitted a representation to the office of the Deputy Commissioner Zinopato, stating that I have submitted my booklet form, which was in a booklet form, my driving license. So, because of the fault of the department, why should I suffer and why should my service be terminated? Because I have undergone the selection process and I was appointed on the merit list.
Okay.
And after I have submitted my representation, the office of the Deputy Commissioner has submitted a letter to me stating that they have found my driving license, which was in a booklet form, in one of the folder.
Okay.
So I have filed a writ appeal challenging,
Yes.
and accordingly, the writ appeal was allowed, and the respondent appointment was terminated, set aside, released, and I was reinstated. And after my reinstatement, I have submitted a representation for my bank wages salary from 30/10/2018 till up to 23/2020. However, the respondent authority till up to now has not disposed my representation nor released my
not disposed of your representation.
yes, and no release, and has not released my bank wages salary. And Lordship, because it was the fault of the respondent authority, the government, because had they been put my records in the first writ petition, then I would not have been terminated. And Lordship, it's a settled principle of law that once termination order is found to be illegal, the constitutional ground of back wages follows as rule.
So I think if your representation, when did you last submit your representation? Dated? Show me the representation.
27/7/2020. It's in my page 28.
Page 28.
Yes.
So I think this petition can be disposed of with an order that his representation should be considered, isn't it? What have you stated in your counter affidavit? That you don't have to pay back wages or what?
No, Lordship, here I have, the state respondent have filed categorically
What is your stand?
categorically stated in paragraph 3, 4, 5, 6, and 7 of our affidavit in opposition. Here, my lord, here the principle of no work, no pay is attractive, number one. Secondly, Lordship, the matter has been settled before the division bench by this court.
Yes.
So, res judicata is attracted.
What
Why?
is-
Because it has
yes.
already been it attains finality, Lordship. If Lordship may kindly come to the page,
Yes.
page 15
Of your
the writ-
affidavit?
no, of the writ petition, Lordship.
Okay.
Since they have annexed the order,
Yes.
I have not, page 15, annexure E. The
Yes.
relevant portion will be at page 26, page 25. Page 25.
Yes.
Page 25, paragraph 26, if I'm allowed to read.
Yes.
No. 26, paragraph 26. Accordingly, the impugn order dated 23/7/2018 passed by the learned single judge in WPC number 156K of 2017 is hereby set aside and quashed. Consequently, the appointment order of the appellant as driver made by the Deputy Commissioner Zinebuto by order dated so-and-so in his establishment pursuant to the selection made in terms of advertisement dated 21/9/2016, noted above, is upheld. Accordingly, the consequent release order of the applicant issued by the Deputy Commissioner Zinebuto, Nagaland under order number WPC number 156K of 2017/891 dated 30/10/2018, releasing the appellant as well as the consequent appointment order number so-and-so dated 30/10/2018 passed by the Deputy Commissioner Zinebuto, Nagaland, appointing the respondent number 1 in the vacancy of the appellant on his release are set aside and quashed. However, very important law. However, the state respondent shall not recover any salary paid to the respondent number 1, that is the earlier petitioner who challenged the appointment of the present petitioner also. Respondent number 1 petitioner in terms of his said appointment order dated 30/10/2018. 27. The respondent number 5, Deputy Commissioner Zinebuto, is directed to terminate the appointment of respondent number 1, Writ petitioner, as driver in his establishment forthwith and to reinstate the appellant in his service with immediate effect. 29. With the above observation and direction, this writ appeal stand allowed. Lordship, here the specific prayer of the appellant here in this appeal is to reinstate the
Yes.
appellant in the post of driver, which was question set aside by the learned single bench in WPC number 156K of 2017, Lordship. That is only the specific prayer, Lordship. And now, Lordship, even the division bench of this court has stated that the state respondent shall not recover any salary that was paid to the respondent number.
Yes,
number
Lordship,
seven,
but that was
number
with
one.
regard to the respondent number 1.
That is with regard to the respondent number 1, Lordship. However, Lordship, Here the petitioner have never stated in the writ appeal that they want this back wages salary, nor they did not claim during those days, Lordship. Lordship, they have filed the present writ petition to release the salary and back wages, which is after court, Lordship. Why? Because they have approached this honorable court after 4 months, Lordship, after he was reinstated in service, Lordship. To that, I would like to place a citation, Lordship, for it, if Lordship may allow. Lordship, the first is to do with on the principle of no work, no pay, Lordship. Here, the petitioner was terminated as directed by the Honorable Court, Honorable Court, order dated Honorable Court order dated 23/7/2018, Lordship, which was challenged by one of the waiting list, who challenged the appointment of the present petitioner, Lordship. And that was question set aside, and the waiting list number 1 was appointed, Lordship. So, Lordship, to that, I would like to let's as one is I have flagged that one, Lordship.
Yes.
No work, no pay. Lordship, this is 2007-11 Supreme Court cases 488. This is Union Territory Chandigarh versus Brij Mahan Court, decided by Justice H.K. Sharma and Lokeshwar Singh Pante. The relevant paragraph will be 490. 490. Third page.
Para?
Para 9, Lordship, if I may allowed to read.
Yes.
Para 9. The direction of the tribunal, which is affirmed by the High Court in our view, is against the all canon of law directed by this court. It is settled law that when an incumbent does not discharge a new duty, the principle of no work, no pay will be applicable. This consistent view has been taken by this court, keeping in view the public interest that any government servant who does not discharge his duty should not be allowed to draw pay and allowance at the cost of public exchequer. Lordship, when the petitioner, who was released on 30/10/2018 by this honorable court to 2020, in that period, Lordship, one namely Aloto V. Tuku.
Okay, yes, I got your point. Now, the DB mentions that he should be to reinstate the appellant in his service with immediate effect,
Yes,
isn't it? So when were you reinstated?
Lordship, I was released on 30/10/2018.
30/10/2018?
No.
No, it cannot be after the judgment and
20
order.
March 2020. It's in my annexure,
Okay.
page 27, annexure.
Yes,
A.
23. So you're okay, fine. I've got your point.
And
Yes.
second, I have flagged, which is also to do with principle of no work, no pay. I'm relying on para 27. Para 27.
This is 2015? No, 2007. Yes, 2015.
2015-17.
Okay.
SCC 625.
Yes, para?
Para 27 law. May I read, Lordship?
Yes.
Paragraph 27. Significantly, the
Yes, go ahead. Go ahead. Please read.
si- page
Yes,
6
yes.
to 33.
Please read.
Significantly, the petitioner did not challenge this part of the order as pointed out above, though he filed two review petitions seeking review of the portion of the order by which the tribunal had given liberty to the state government to pass fresh order of suspension, but did not even ask for review of the order denying him salary for the period after so and so. The order of the tribunal was not even challenged before the High Court, and thus it became final that apart the petitioner never joined the duties and therefore he cannot claim salary on the principle of no work, no pay as well. Lordship, here also the petition has been dismissed, Lordship. And here also the same principle has been applied in this case, Lordship.
Yes.
And
Okay.
Lordship, secondly, Lordship, on res judicata, Lordship. Here, what happened, my Lord? Here, the writ appeal filed by the petitioner attained finality, Lordship. And nowhere in the writ appeal they have prayed before the honorable court for back wages. Their only prayer before the honorable court was to reinstate the petitioner, Lordship. And even that has not been challenged by the petitioner, Lordship. So, Lordship, I have flagged the three res judicata. I'm relying on paragraph 11, 12, 13, 14, and 15. This is 2020 SCC online. If my Lord has got it.
Yes.
Punyaram Srivas versus State of Chhattisgarh through the Secretary, Department, Human Resources and Manpower and others. Lordship, may kindly come to paragraph 11, the relevant paragraph, Lordship, of course.
Yes, yes.
May I read, Lordship? Para 11. Principle of res judicata are applicable to the writ proceeding with equal force. The principle of res judicata contains the rule of conclusiveness of the judgment, which is based upon the maxim of Roman jurisprudence, interest replica ad sit fins litium. 12. Honorable Supreme Court, in its recent judgment in the matter of Subramaniam Swamy versus State of Tamil Nadu, 2014 5 SSC 75, has helped us. The literal meaning of res is everything that may form an object of rights and includes an object, subject matter or status, and res judicata literally means a matter adjudicated, a thing judicially act upon or decided, a thing or matter settled by the judgment. Res judicata pro vertet equipeter is the full maxim which has over the years shrunk to mere res judicata, which means that res judicata is accepted for truth. The doctrine contains the rule of conclusiveness of the judgment, which is based partly on maxim of Roman jurisprudence, interest replica ut sit fins litium. It concerns the state that there be an end to lawsuits, and partly on the maxim nemo that bis vexeri pro on et edim cos. No man should be vexed twice over for the same cause. 13. If we consider the facts of the case at hand in the light of aforementioned verdict passed by the Honorable Supreme Court in the matter that Subramaniam Swamy Supra, the subject matter of earlier writ petition and the litigation was one and the same as projected in so and so, second writ petition, and the relief sought for are also same. Case was finally decided on merit. In the earlier round of litigation in writ petition and in writ appeal filed by the appellant in the first round of litigation, after raising some arguments, was withdrawn with the liberty to file representation before the department, but without any liberty to challenge outcome of the representation. 14. In view of the above facts and order passed in the writ petition in the first round of litigation on the same issue and relief, very important, Lordship, and relief sought for by the appellant, the order passed in so and so has become final. We do not find any infirmity in the order passed by the learned single judge, either in law or on facts. The appeal being devoid of any substance which is liable to be and is hereby dismissed. Lordship. The same principle has and the same facts and situation in this present case. Lordship.
Okay,
And-
that's a submission,
and Lordship, afterthought, Lordship. Lordship may kindly, this is 2021 SEC online. This is Rekha Raghunath Uttar versus
Para? Yes, I've seen it. So para?
Para 15, 16, 17, 18, and 19. It's a short paragraph, Lordship. May I read, Lordship?
Yes.
Para 15 start from last page, Lordship. May I read, Lordship? 15. In this backdrop, when the statement made in paragraph 12 of the instant application regarding the health condition of the appellant is perused, it becomes clear that such a ground is taken for the first time before this court, with the intention to seek sympathy of the court. To support the same, a certificate of doctor dated so and so is placed on record. A proper appreciation of the said certificate will show that according to the doctor who issued the certificate, the applicant was unable to walk at the time when certificate was issued, having developed an ulcer on her leg. It is significant that while the aforesaid certificate was dated so and so, on the basis of which the applicant claims that she was totally bedridden, the aforementioned civil revision application was filed on 38, 2018, and it was perused before this court. The appellant was also resisting the execution proceedings. The manner in which the health condition of the appellant is now sought to be projected, and the nature of the documents in the form of certificate dated so and so is placed before this court. It is appears that the ground of poor health condition is raised as an afterthought on the part of the applicant. 16. Although it is laid down in various judgments that the endeavor of the court should be decided matters on merits, yet it is also recognized that when sufficient cause is not demonstrated for condonation of delay and rights are crystallized in favor of the opposing party, the court ought not to show sympathy and upset rights that have already been crystallized. 17. In the present case, the suit was filed as far back in the year 2009. The decree in favor of the respondents was passed on 29/11/2014, and the appeal against the same was dismissed as far back on 13/10/2015. The accompanying second appeal was eventually filed on 2/5/2019, which was about 4 years after the appeal was being dismissed and the decree was confirmed. This court finds that the applicant has not been able to demonstrate sufficient cause for continuation of delay. At this stage, an attempt was made on behalf of the applicant to argue on the merit of the matter. While considering the question for continuation of delay, it will not be appropriate for the court to go into the merits of the matter, and therefore the said contention were not considered. 19. The learned counsel appearing for the applicant placed reliance on the judgment of the Honorable Court in case of Dipa Chandra Shankar Moore versus Balu Gangaram Moore, judgment so and so. The said judgment is clearly distinguishable for the reason that in the said case, the court was considered a case of an application seeking a side ex parte degree. The court on facts found that the sufficient cause was demonstrated by the applicant for the continuation of delay, as no deliberate inaction or lack of bona fide was imputable to the party seeking continuation of delay. In view of the finding rendered herein above in the present case, the aforesaid judgment of the Supreme Court is not applicable, hence the application is dismissed. Lordship, here the petitioner was reinstated in service on 23/2020, Lordship. And thereafter, after the lapses of 4 months, he have submitted a representation to the Deputy Commissioners in Nepoto, but without explaining any delay as to why he has submitted the application only after 4 months, Lordship. So, maybe the petitioner have realized that since he has already been reinstated, he should also claim for the back wages, Lordship. So which is after foreclosure.
Okay. Yes.
Lordship,
Rebuttal? Yes.
with regard to the principle of no work, no pay, the petitioner back wages salary would not apply in this instant case because I was willing to give my service. However, I was released from my service.
Okay.
And Lordship, I would also like to place one apex court judgment. 2013 10 SCC 324 Dipali Gundu Surwas versus Kranti Junior Adhyapak Mahadev Yalana.
Yes.
The relevant para is at para 21 to 24. Lordship, 21 to 24.
Yes. Go ahead.
21, para 21, the word reinstatement has not been defined in the Act, and the rules as per Shorter Oxford English Dictionary, volume so and so, the word reinstate means to reinstill or re-establish a person or thing in a place, station, condition, etc., to restore to its proper or original state. To reinstate afresh, and the word reinstatement means the action of reinstating, re-establishment as per law lexicon. So and so, the word reinstate means to reinstill, to re-establish, to place again in a former state, condition, or office, to restore to a state or position from which the object or person had been removed. And the word reinstatement means establishing in former condition, position, or authority. Reinstatement of a disposed prince. As per Merriam-Webster dictionary, the word reinstate means to place again as in position or in a former position, to restore to a previous effective state. As per Black Law's dictionary, so and so reinstate means to reinstill, to reestablish, to place again in a former state, condition or office, to restore to a state or position from which the object or person had been removed. Para 22, the very idea of restoring an employee to the position which he held before dismissal or removal or termination of service implies that the employee will be put in the same position in which he would have been but for the illegal action taken by the employer. The injury suffered by a person who is dismissed or removed or is otherwise terminated from service cannot easily be measured in terms of money. With the passing of an order which has the effect of severing the employer-employee relationship, the latter's source of income gets dried up. Not only the employee concerned, but his entire family suffers grave adversities. They are deprived of the source of sustenance. The children are deprived of nutritious food and all opportunities of education and advancement in life. At times, the family has to borrow from the relatives and other acquaintance to avoid starvation. These sufferings continue till the competent adjudicatory forum decides on the legality of the action taken by the employer. The reinstatement of such an employee, which is preceded by a finding of the competent judicial, quasi-judicial body or court that the action taken by the employer is ultra vires, the relevant statutory provisions or the principles of natural justice entitles the employee to claim full back wages. If the employer wants to deny back wages to the employee or contest his entitlement to get consequential benefits, then it is for him, her, to specifically plead and prove that during the intervening period, the employee was gainfully employed and was getting the same emolument. Lordship, this is important because during my release, I was not gainfully employed anywhere. The denial of back wages to an employee who has suffered due to an illegal act of the employer would amount to indirectly punishing the employee concerned and rewarding the employer by relieving him of the obligation to pay back wages, including the emoluments. Para 23, A somewhat similar issue was considered by a three-judge bench in Hindustan Tin Work Private Limited versus Employees in the context of termination of service of 56 employees by way of retrenchment due to alleged non-availability of the raw material necessary for utilization of full installed capacity by the petitioner. The dispute raised by the employees resulted in award of reinstatement with full back wages. This court examined the issue at length and held. It is no more open to debate that in the field of industrial jurisprudence, a declaration can be given that the termination of service is bad and the workman continues to be in service. The specter of common law doctrine that contract of personal service cannot be specifically enforced, or the doctrine of mitigation of damage, does not haunt in this branch of law. The relief of reinstatement with continuity of service can be granted where termination of service is found to be invalid. It would mean that the employer has taken away illegally the right to work of the workman contrary to the relevant law, or in breach of contract and simultaneously deprived the workman of his earnings. If thus the employer is found to be in the wrong as a result of which the workman is directed to be reinstated, the employer could not shrink his responsibility of paying the wages which the workman has been deprived of by the illegal or invalid action of the employer. Speaking realistically, where termination of service is questioned as invalid or illegal, and the workman has to go through the gamut of litigation, his capacity to sustain himself throughout the protracted litigation is itself such an awesome factor that he may not survive to see the day when relief is granted. More so in our system, where the law's providal delay has become stupefying. If after such a protracted time and energy consuming litigation during which period the workman just sustains himself untimely, ultimately he is to be told that though he will be reinstated, he will be denied the back wages which would be due to him. The workman would be subjected to a sort of penalty for no fault of his and it is wholly undeserved. Ordinarily, therefore, a workman whose service has been illegally terminated would be entitled to full back wages except to the extent he was gainfully employed during the enforced idleness. That is the normal rule. Any other view would be a premium on the unwarranted litigative activity of the employer. If the employer terminates the service illegally and the termination is motivated, and in this case is to resist the workman's demand for revisions of wages, the termination may well amount to unfair labor practice. If such circumstances, reinstatement being the normal rule, it should be followed with full back wages. Lordship,
Anything else? Same, this thing?
yes, and para 24 I will. Another three-judge bench considered the same issue in Surendra Kumar Verma versus Central Government Industrial Tribunal cum Labour Court and observed. Plain common sense dictates that the removal of an order terminating the services of workmen must ordinarily lead to the reinstatement of the services of the workmen. It is as if the order has never been, and so it must ordinarily lead to back wages too. But there may be exceptional circumstances which make it impossible or wholly inequitable vis-a-vis the employer and workman to direct reinstatement with full back wages. For instance, the industry might have closed down or might be in severe financial doldrums. The workman concerned might have secured better or other employment elsewhere and so on. In such situation, there is a vestige of discretion left in the court to make appropriate consequential orders. The court may deny the relief of the reinstatement where reinstatement is impossible because the industry has closed down. The court may deny the relief of award of full back wages where they would place an impossible burden on the employer. In such and other exceptional cases, the court may mold the relief, but ordinarily the relief to be awarded must be reinstatement with full back wages. That relief must be awarded where no special impediment in the way of awarding the relief is clearly shown. True occasional hardship may be caused to an employer, but we must remember that more often than not, comparatively for greater hardships in certain to be caused to the workman if the relief is denied, than to the employer if the relief is granted. Lordship.
Yes. Okay.
So, Lordship, stated by a learned friend, I was not gainfully employed during my termination period. And as such, I'm entitled for my full back wages salary.
Okay, we'll make it a CAV. Any other point to mention? You're saying that no work, no pay. That's the main point.
No work, no pay. Secondly, Lordship,
Res judicata.
res judicata. Since Writ appeal, they did not pray before the Honorable Court for back wages. They only pray before the Honorable Court for reinstatement of his service.
Lordship, but see, for in the Writ appeal, I was terminated from my service. I was aggrieved. So I have challenged.
So after
So after my reinstatement, only I have
yes.
submitted my representation. So res judicata does not apply in this case.
So
Because this is not a multiplicity of.
Yes, okay, I've got your point.
during his termination, Lordship,
Oh.
one incumbent was appointed, and even the in the decision bench, this honorable court has clearly stated that not to recover from the respondent number one
Yes.
petitioner, Lordship. So it will amount if the state is to pay.
Is it against a post? What is it? A sanctioned post or what? What is the
Yes,
post?
yes, Lordship. Selection
Yeah.
process was done.
Okay.
Selection
Interview,
process was
written
done, but in
examination.
the meantime, he was terminated, and one incumbent was appointed.
Okay,
Lordship.
he was
And during-
initially appointed
Yes,
and then
initially I was
terminated.
He was initially appointed, and since waiting list number one challenged his appointment,
Okay.
saying that
Yes, yes.
he have submitted the fake certificate.
Mhm.
So basing on that, he was terminated. During those terminated.
Okay,
time-
now, yes, I got your point. So in this judgment that is cited, 2013,
Lordship.
the one, what is the nature of the job, the work for which he was reinstated?
Lordship, they were laborers.
Laborers.
Yes.
Okay.
And after he was joining the service, he had never submitted any representation to the respondent whatsoever. Only after 4 months, and that also without any explanation, Lordship. Without any valid
So what does that
explanation.
indicate?
That indicates that
Is there some limitation as to when you can pay for back wages?
No, at least the petitioner has to explain as to why he has submitted the representation after the belated stage. After the lapse of 4 months.
Cannot be counted as a belated stage. After my
He
reinstatement.
was reinstated and only after 4 months, Lordship. And that has not been explained. And the law is very clear, Lordship. Lordship, in fact, it's a settled principle of law.
No,
In fact,
what does
when-
law say? So after 4 months, he's asking for back wages. So
Yes,
he's
Lordship.
saying this is
There is a
very
delay.
late.
There is a continuation of delay, and that has never been explained.
Where is the continue? What is the limitation?
Midterm
Huh.
testing.
Give me that. What are you basing that on? That is come.
Lordship, that I have in paragraph
Of which judgment?
judgment, Rekha Raghunath.
A citation?
Yes, Lordship.
Which one? Okay, 2021. Yes.
Paragraph and 15, 16, 17, 18, 19, 20 and 21. Lordship. And more particularly,
Okay, this is concerning the work compensation for your leg, isn't it? Yes.
Lordship, it will
So
amount
how's-
if the
This
state
is
has to pay,
reinstatement, huh?
then it will amount to double jeopardy, Lordship. Because earlier the court has clearly given a direction that not to recover from the respondent number one, Lordship. And if we are to recover, Lordship, to the petitioner, then we have to get recovery from the petitioner.
So you're saying
Earlier.
that
Yes,
this
Lordship.
sentence not to recover would imply that?
Lordship.
all that is not mentioned. So the court in its deep judgment has said that he should be reinstated, but nothing is mentioned about the back
Nothing
wages.
is mentioned, nothing is mentioned, Lordship,
And
regarding
at the same
wages,
time,
Lordship.
so the interpretation of this judgment will have to be seen, or there's an option whether this judgment, when was it? The dated?
Dated to, judgment order dated 26 to 2020, writ appeal. The petitioner has to overcome the writ appeal, Lordship. If he is agreed by this order, Lordship, since it attempts finality writ appeal filed by the petitioner.
No, Lordship, here it does not.
Yes, it doesn't.
Lordship.
Anyway, I've got your point. You're saying that the state government does not have a provision now because they have paid. It's not.
If at all we have to recover then from the respondent number one earlier, which I paid to the
And in fact, Lordship,
the incumbent, Lordship.
being a government employee, every man, one increment is given to a
With
government.
no fault of ours, Lordship.
And in fact,
How
I have even
we are
lost
going to pay,
a year increment also, Lordship, in my service.
How we are- how
And
we
it
are
is the
going to pay,
fault of
Lordship.
the respondent
Lordship.
authority.
No, Lordship. In
Because
fact,
of their fault, only I was terminated.
no, in compliance with this honorable court, we have terminated the petitioner, Lordship, and
In compliance, however, it was the fault of the
and
respondent
reinstate
authority.
the Lordship.
You have
So we don't follow
reinstated.
ours, Lordship.
Yes, but
We are in compliance with the honorable court, Lordship.
you have complied with the
Lordship,
court's order, but concerning the back wages, that is silent in the judgment, isn't it? So we'll have to see, consider this
Lordship,
matter
Lordship.
when the court is silent in that matter.
Yes,
Your point is that now we don't have any head in which to pay.
nothing.
I think that is
It
the
has
main
attained
thing.
finality, Lordship.
Oh.
It has attained finality.
No, not fair.
If
You see, the question of back wages was never raised at that time
Lordship,
because he
Lordship.
didn't
Now
know.
it's a new person.
Because I don't know whether I will be reinstated or not.
No, but they should have prayed before the honorable.
Because without passing the order, judgment, how can I pray for back wages?
But in your prayer portion, anyways, we'll consider the matter, okay? Heard Mr. So-and-so. Your good name, please?
Yes, single.
Esinglo, learned counsel for the petitioner, along with Mr. So-and-so, learned government advocate for the state respondents. Matters, after hearing both the parties, matter is reserved for judgment in order. Yes.
Much obliged.
Yes.